everyone, and welcome to Daily Newspaper Analysis, which is brought to you by LawSikho. So today we will be doing the newspaper analysis for 29th as well as 30th March 2022. That is for yesterday and today. So this might be a little lengthy session today, but please hold in patience. We'll definitely wrap up as soon as possible. So today we'll be covering three editorials. The first one is from the Hindu newspaper, which is titled as Unreformable Criminal Justice. So this article talks about the precise problems that the Indian criminal justice system faces, though we have discussed a similar article many times before. So we will take this up in a brushing up manner, and we'll see that what all are the major problems that the Indian criminal justice system faces. The second article is from the Indian Express, which is titled as Recognizing Minorities. So this basically will give us an idea as to how the Constitution and in what manner does the Constitution of India recognize the minorities, who are they, and who all can be considered under the group of minorities. Thirdly, we have another article from the Indian Express from today, that is from yesterday, that is biosamples for crime files. So this talks about the new bill that has been proposed about collecting the biosamples that would be kept with the NCRB. So what is this entire bill? What will be the major implements of this bill? And the pros and cons will be discussed here. Fourthly, we have the news update column in which we'll be covering important news points for our prelims exam specifically. And finally, we will be covering up and wrapping up with the legal news for the days. Let's understand the first article that talks about unreformable criminal justice. So India's criminal justice system is ingrained with problems that has likely made its way into the psyche of the functionaries. Now, as we know, even if we talk about the Indian Penal Code or if we talk about the Criminal Procedure Code, so they are, the laws. And specifically, we talk about IPC, it is a legal system that was brought up in 1860. So it's like more than 100 years have actually passed that we have had these legislations, and for CRPC also a lot of years have passed. Now, in this circumstance, it is pointed out that the Indian criminal justice system is suffering with a lot of lacunae, and that is why with the growing society and dynamic system of criminal justice and reforming in this, we need to bring changes, and thus our criminal justice system should not remain unreformable in that manner. Let's understand the problems that plague or that hamper the present criminal justice system issue-wise. So the first is disposal of the pending cases. As we know that more than 4.4 crore of the cases are pending, and it is a problem that shall persist in the foreseeable future because till date, even after having fast-track courts, tribunals as well, this huge burden on the system has not been able to be reduced significantly. Second, we have the second issue is that justice mechanisms remain inaccessible for the marginalized community. Even after having the provision of free legal aid in the country, we are still not able to provide justice mechanism to a lot of marginalized communities, and our judicial system follows a transcendental institutionalist approach rather than capacity building, and hence marginalization of vulnerable sections is inevitable in this situation, because in this regard what happens is that we, instead of expanding the area or the jurisdiction of these courts in a way that they should be easily be able to take cases from the marginal segments, we rather have gotten stuck into the complexities of the complete system. Now, the third issue is abuse of power by the police. Of course, we know that the custodial deaths have been on a highest, since the previous few years, and that is why police has significantly been abusing the powers that has been given to this entire team. So our stress on criminal control values further aggravates this issue. Fourth issue is the crime prevention. The path we are marching towards is an utopian goal, which basically is way too ideal perhaps to be achieved. So successful empirical studies have shown that a higher degree of punishments has little effect on actually lowering the rates of crimes. Now here definitely we can bring up the example or the discussion of capital punishment, that how much is it actually able to cater to its very purpose, because very a big incident for this matter we can take that even after the Nirbhaya case and they were given up the capital punishment, still so many heinous rape crimes have been committed in the country, and we can clearly see that the deterrence purpose that we were trying to bring forward through these high degree punishments, that has not been purposefully achieved, and that is why maybe we should look forward in reforming the criminal system and maybe having a more of reformative approach rather than having a deterrent approach. Fifth issue is diversionary principles in the treatment of prisoners are yet to materialize. By this, we mean that several law commissions and committees have also recommended non-custodial measures of punishment, and this leads to overcrowding in the prisons. And as we know that even till the date, most of even more than 50% people who are there in the prison, they are not serving their jail term, rather they're under trial prisoners, which is definitely a clear violation of their human and fundamental rights. Sixth issue is that there is a significant dearth of state-sponsored data collection. So little effort so far has been made by the states, thus to map the perceptions of justice by victims and the common man as to what actually, according to the common people, do they consider as justice. Like, it definitely might be that some people, might believe in the theory for an eye for an eye and tooth for a tooth, but there might be some people who might believe in the reformative theory. So for that matter, a consensus needs to be drawn, and according to this perception of the society, the entire criminal justice system should be reformed. So finally, the present researchers and policy makers must carry forward and take these issues into consideration. With this, let's discuss the second article for the day, which talks about recognizing the minorities. So there has been an ongoing friction as the central government proceeds to grant Hindus a minority state stance in states like Kashmir, Punjab, and Lakshadweep. Now, as we know, generally, apart from Hindus, other religious communities like we have Muslims, Jain, Sikh, etc., they constitute the minority communities in the country, because definitely approximately 80% population, 70 to 80% population of the country is Hindu. But that is not the case in states and union territories that have larger populations of other religions. Like, for example, they are given here are Kashmir, Punjab, and Lakshadweep. So in that regard, the central government has proceeded further to grant Hindus a minority status in these particular states and union territories. Now, the Supreme Court gave the centre 4 more weeks to place its stand on the plea, and basically that challenges the centre's power to notify minorities under the National Minorities Act 1992. Now let's see that under the Indian Constitution, how have we defined or recognized the minorities? Now, Article 29 of the Constitution deals with the protection of minorities and states that any section of citizens having their own distinct language, culture, and script has the right to protect the same. Now here, please pay attention that Article 29, basically, it does not give any exclusive right basically to the minorities itself. Rather, it also expands its forum and says that any section of the citizens that have their own distinct language, culture, or script, and they want to preserve it, so definitely will have the right to protect it. But the second clause, as well as Article 30, it states that all minorities, irrespective of their basis in religion and language, are allowed to run educational institutions. So please remember Article 29, but Clause 2 and Article 30, they talk about the minorities and specifically about minorities. But to be very, very precise, it's Article 29, and Article 30 is here about the basic any minority, irrespective of their basis in religion or language, are allowed to run educational institutions. Now, again, you have to note here that minorities here under Article 30 have been considered irrespective of their basis in religion or language, which means that the entire area that has been covered, or the definition of minority, is quite wide and exhaustive under Article 30. Now, Article 350A states that there shall be a special officer for linguistic minorities who shall be appointed by the president. Now, it is his duty to safeguard the communities based on linguistic minorities. Now, the Supreme Court has also ruled on the meaning and extent of minorities. In the case of T.M. Pine in 2002, it said that the court held that the Arya Samajis were minorities in Punjab. And in Bal Patil case 2005, the court stated that the legal position regarding unit of determining status of both linguistic and religious minorities are based, and they would be decided finally by the state. And hence, this move that the center has taken is being challenged, that it is not actually under the purview and jurisdiction of the central government to take such decisions. Now let's understand about this concept of minority versus majority, which is basically like a class struggle. So the population number theory is not entirely true. So basically, if we just consider that, let's say out of 100 people, 60 belong to a particular religion, 10 belong to a particular religion, and the rest, all belong to some particular religion, that is a population number theory. Now, this is not considered to be the only and just the only good enough criteria for considering a class as minority. Rather, it says that other things, like for example, their religion, their linguistic, basis, as well as it should also be awarded to the same to individuals from the LGBTQIA plus community as well. So basically, it's about having a different culture, religion, language, etc. And that is why the meaning of minority, or the definition of minority, should be widened even more. So the linguistic minority is a difficult stance to hold. Supposedly, a Tamil Brahmin can run a minority educational institution anywhere in India apart from Tamil Nadu, because in Tamil Nadu, Tamil Brahmin would not be a minority, because definitely there would be in a majority population. Now, there have been other inconsistencies when it comes to categorizing minorities. So Article 30 of the Constitution does not mention that minorities may necessarily be determined at the state level. So there is no clarity over here as such to be given here. Now, that is why this debate between minority and majority, many a times it is said that it varies along with the language, along with the religion, along with the geography of the country as well. And that is why this needs to be clarified on the primary basis. So in the Bal Patil case, the court had observed that the religious minorities lists must be done away, calling for an assimilation. And this is violative. It said that it is violative of Article 25, and that is basically about secularism, and it does not bar the birth of a new generation and the preaching of the same. With this, let's discuss the third and final article for the day, which talks about biosample for crime files. So the government introduced the Criminal Procedure Identification Bill 2022 in Lok Sabha. This bill proposes to allow law enforcement agencies to collect and retain. So you have to remember that the law enforcement agencies would not only be allowed to collect, but also to retain the physical and biological samples. That basically that would be the biometric data and the physical data, including fingerprint and retina scans, just like we have in our Aadhaar cards as well. So let's understand that what are the contents and contentions of this particular bill. So the section 2, clause 1, subclause B of this particular bill allows measurements like finger impression, palm imprints, footprints, photographs, iris, that is the iris and retina scan, that are the parts of the eye, and handwriting samples as well. Now the law also seeks to replace identification of Prisoner Act 1920, and currently the law is intended to apply to 3 types. Firstly, those who are convicted of an offense that is punishable by law, simple as that. Second category would be those people who were ordered to give security for good behavior or maintaining peace. Specifically, it applies to the habitual offenders. And third class, or the third category, is that those arrested in connection with an offense that is punishable under any law enforced or detained under 2 acts. First is the National Security Act or the Public Safety Act. Now, a person can refuse to give his data except in the situations if they have assaulted women or children, or that person has been punished with imprisonment not less than 7 years. So if this is not the case, then they can refuse collection of their data. Now, the bill states that the data shall be stored with the National Crime Records Bureau. Now, this also forms an important part that can be asked in a prelims exam, that the data under this particular bill will be collected by which authority? So the correct answer would be National Crime Records Bureau, that is the NCRB. Now, issues of the bill. So firstly, it lacks clarity. So several provisions are not clearly defined, although they challenge the fundamental rights. So definitely here, a good amount of tussle can be seen between the 2 provisions. Secondly, the law violates the fundamental rights, and thus, firstly, of course, if we talk about the right to equality, it also violates primarily right to privacy. So this is repeatedly said that Parliament cannot bring laws to nullify the fundamental rights. And even if this act, which is violative of fundamental rights, even if it becomes an act, definitely it might be struck down. It would be struck down by the Supreme Court under its power of judicial review. And thirdly, the bill also nullifies the right to be forgotten for the prisoners. By simply understanding right to be forgotten is that if at all any data pertaining, let's say about me, it is floating on any particular internet website, or government has my data on any particular internet portal, internet website, so I, as a person, will have the right to be forgotten, which means I can request the government to erase my data from any online resource so that I can keep a check, or I can actually maintain my privacy. So it also says that the bill also nullifies the right to be forgotten for the prisoners. So that has to be noted out here. Furthermore, we have to remember that in India, the Personal Data Protection Bill is still a bill. So if at all such crucial information about an individual is collected and retained by the authorities, definitely we should have in balance, and we should have in concrete form the Personal Data Protection Bill, so that if at all anything happens, so safeguards, legal safeguards are always available. But that, of course, is not the current case. Now let's discuss what do we have for the news updates. Firstly, Tawadkar has become the new speaker for Goa Assembly. So Bharatiya Janata Party has nominated Ramesh Tawadkar, a former minister and member of the Scheduled Tribes community, for the post of speaker in the newly elected Goa Legislative Assembly. He represents the southernmost constituency of Kanakona. Second, FedEx names Subramaniam as next CEO. So FedEx has named Raj Subramaniam as its next CEO, who shall succeed Fred Smith. So he's currently the president and the COO, and is set to assume his new position from 1st of June. Thirdly, Meghalaya, Assam take key step to resolve border row. So basically, Assam and Meghalaya, they have had a border dispute in approximately 6 places in the presence, and now this actually will be taken care of in the presence of Union Home Minister Amit Shah. This makes the state insurgency-free, resolving a 5-decade-long problem with the Bodo outfits. Fourthly, massive fire at Sariska Tiger Reserve. Now, another important question for us that which state has the Sariska Tiger Reserve? So please note it is Rajasthan that has the Sariska Tiger Reserve. So a fire has been broken out in this reserve, and the Indian Air Force helicopters that have been equipped with water sprays are battling to bring down the fire under control. Let's see, what do we have for news update segments today? This has to be, yes, and the fifth point, guys, basically is Kozhikode to vie for UNESCO City of Literature. So few cities in Kerala can boost the legacy of writers equivalent to Vaikom Muhammad Bashir, Sanjayan S. OK, Potikat, M.T. Vasudevan Nair, N.N. Kakkad, and U.A. Khadir. So hence it was a natural that Kerala Institute of Native Administration is to be branded as the metropolis of literature with the assistance of UNESCO. Here also please note that recently Chennai and Varanasi have also been added to the cities of music list of UNESCO. Sixth, Lok Sabha noted to include 2 tribes on Tripura scheduled tribe list. So Lok Sabha on Monday passed a bill to include the Darlong community and as a sub-tribe of the Kuki in the list of scheduled tribes of Tripura, even as opposition members call for a more comprehensive legislation on including communities in the scheduled caste and tribes list rather than in a piecemeal allocation. Now here, what important thing that you have to note here is that these 2 tribes, basically Darlong, will be becoming a sub-tribe of the Kuki tribe. So Darlong and Kuki, these 2 tribes belong to which state? So the correct answer here would be Tripura. Please note in the previous static geography questions, many states have asked these local tribes of the states. So you always have to keep a check on that. Last we have is the 94th Academy Awards for Oscar. So Coda, C-O-D-A, won the Best Picture and Will Smith bagged the Best Actor Award. So Jessica Chastain won the Best Actress. Dune bagged a total of six Oscars, and The Queen of Basketball was the Best Short Documentary. Let's see, finally, that what do we have for the legal news today? Firstly, Juvenile Justice Act. So it says that the preliminary assessment under Section 15 is not required for grant of bail under Section 12, says the Madhya Pradesh High Court. So Madhya Pradesh High Court, Gwalior bench recently held that power of Juvenile Justice Board under Section 12 does not require any preliminary assessment under Section 15 of the Juvenile Justice Act. Secondly, basically that is the Kerala rail silver line. So single bench could not have a stalled prestigious project. So Supreme Court refuses to interfere with survey process. So the Supreme Court on Monday refused to interfere with the social impact assessment and the land survey for the silver line project, that is a high-speed rail corridor project of Kerala Rail Development Corporation in Kerala. So another piece of information that we get here is that the silver line rail project is related to Kerala. Third, Code of Civil Procedure, or basically CPC, second appeal, it says that it can't interfere with orders solely on ground of sympathy. Substantial question of law must be there, and this has been said by the Delhi High Court. So it says that Section 100 of the CPC gives a procedural right of second appeal to either of the parties to a civil suit who have been adversely affected by the order passed and lies only in front of the High Court. Fourthly, Article 226, that is, it says that High Court has to deal with grounds or issues raised in a writ petition and pass reasoned order, says the Supreme Court. As we know that the constitutional remedies right is Article 32 for the Supreme Court and Article 226 for the High Courts. So the Supreme Court observed that it is the duty of the court to deal with the grounds that have been raised in the writ petitions. So this was all for the day. We hope you liked the session. If you did, please give it a thumbs up and do not forget to subscribe to our channels. If you wish to download the PDF of today's slides, you can join our Telegram channel. The link to this is there in the description box below, or you can scan this QR code that you can see on your screens right now. Also, for other crisp and exam-oriented content, please follow us on our official Instagram channels for Judiciary, CLAT Prep, UGC Net, and Law Finance exams. Thank you so much.